For decades, the legal battle over abortion focused on the U.S. Supreme Court and its guiding document, the U.S. Constitution. Now, with Roe v. Wade overturned, the legal spotlight has shifted to the states, where abortion supporters and opponents must contend with 50 different constitutions that, in many places, guarantee rights more broadly than their federal counterpart. The legal chaos has already begun. In a half-dozen states and counting, lawsuits argue that new restrictive abortion laws are in violation of state constitutions. So, too, the stakes have grown for ballot measures scheduled this year to amend those constitutions, whether to protect the right to an abortion or eliminate it. For anyone who thought, oh, Roe v. Wade is done and now this whole thing is over, I have bad news, Mary Ziegler, an abortion law expert. This is just going to be an even more complicated chapter that we're entering into. And experts say the uncertainty could continue for years to come, given the relative ease of amending state constitutions and the judicial elections in many states that can result in rapid changes to a court's ideology. In the days since the Dobbs decision, abortion rights organizations have filed lawsuits challenging state courts to find a right to abortion in at least 4 states, including Utah, Kentucky, Idaho, and Mississippi. Some other active legal challenges, including lawsuits in Wisconsin, Louisiana, and Texas, do not ask judges to evaluate the constitutionality of abortion rights. Rather, they point to administrative errors or other enforceability questions as reasons for judges to invalidate the laws. They joined 2 lawsuits in Florida and Michigan that were filed in anticipation of Roe being overturned. At question in Michigan is a nearly century-old abortion ban that had long gone unenforced. In Florida, Governor Ron DeSantis signed a law in April that would ban abortions after 15 weeks. It has since been challenged by Planned Parenthood, which has asked a judge to block the law before it takes effect at the end of the week. All of the legal challenges emphasize the disruptions to a person's life and the risks to their health and economic security that come with pregnancy and childbirth. But the lawsuits are not identical. Each appeals to specific lines of legal theory unique to each state, citing different state provisions and different case histories to support their arguments. In Utah, Planned Parenthood's suit argues that the state's trigger ban violates 7 different sections of the Utah state constitution. A judge has temporarily blocked Utah's abortion ban as a result of the lawsuit, allowing abortions there to resume for 14 days. The Idaho lawsuit points to a history of legal decisions by the Idaho Supreme Court that advocates say indicate a right to intimate familial decisions, including procreation.